Paul. A final speaker in this set is James Golden. James is the director of Quigg Golden, specialists in construction dispute resolution. Many of you know James, is no stranger to Galway, and has presented at many seminars with CIF, etc. James is an adjudicator and qualified barrister, but non-practicing at the moment. His wide experience with many major consultants and contractors throughout the UK and Ireland. He's worked in Hong Kong and has a lot of international adjudication experience. James is widely experienced in all aspects of dispute resolution, large-scale project management. His experience includes acting as expert witness in arbitration and litigation. He specialises in the growing area of dispute resolution under the new engineering contract. James also is a training tutor on the NEC forms for the Institution of Civil Engineering. Today, James is going to update us on the Construction Contracts Act 2013. Thank you.
Thanks, Martin. Thank you for having me down here today. I come to Galway often. I always enjoy coming to Galway. Whenever I come here in business, the sun always shines. I come here on holiday frequently, and if somebody could arrange the same courtesy when I come on holiday, that would be great. Martin's introduced me and what we do at Quigg Golden. We do dispute resolution. We do procurement disputes. We do disputes between main contractors and subcontractors. We do disputes between main contractors and their clients. We do disputes between clients and their consultants. We even now do disputes between main contractors, subcontractors and the consultants, and we do it here and in the UK. John, in his presentation, listed a number of issues which then Paul touched on when he spoke. He talked about an industry which was riven with disputes, where cash flow and a culture of contention was endemic. He talked about procurement issues, about difficulties getting things onto the work site through the procurement process and all the rest of it. And on behalf of the shareholders and directors of Quigg Golden and our families, I'd like to thank the industry for finding itself in that position. I'd just like to point out that there is a silver lining. And I wouldn't like you to think that all of that hard work and falling out with each other was going unmissed. This morning I'm here to talk about the Construction Contracts Act, which John touched on earlier on. Give you a little bit of background to the Act. Talk about what the purposes of the Act was and how that's hopefully going to be achieved. And talk about the payment and adjudication provisions under it, and hopefully have this all done in time to have our coffee at 11 o'clock. I'll see what I can do. During the boom, there was money everywhere, and looking back on it, it was like nirvana. Nobody really fell out with anybody because everybody was so well paid. In fact, that was not the case. Throughout the early part of this century, and certainly in the late 90s, the Irish construction industry continued to have a high level of disputes, particularly at the subcontract level. One of the things that I was very conscious of working particularly between the Northern Irish work that we do and the Southern Irish work that we do, was the stark difference in terms of remedies for particularly subcontract issues. And subcontract abuse was endemic and has really only got worse. And that's not necessarily in stark contrast to the situation in the UK, but at least in the UK, subcontractors had a remedy through statutory payment provisions and a rapid dispute resolution system in adjudication, a certain and rapid dispute resolution process. So a firm like us, if somebody came to us with a problem, if it was in Newry, we could give them a solution because they had recourse to adjudication. Whereas if they brought exactly the same problem to us in Dundalk, frequently we would not. And this to me was just wrong. I mean, why here, where we are closer to our government than we are in the UK, we couldn't put in the statute books a similarly sensible piece of legislation was beyond me. And it took the construction industry to pull itself apart after 2008 for somebody to take action. And Senator Quinn managed to get on the statute books the Construction Contracts Act. And that's where it came from. It came from fixing subcontract problems. Now, it came from a different place than the similar law in the UK. And the similar laws now across the whole Commonwealth in parts of Canada, certainly throughout Australia and New Zealand, there are similar construction contracts, regulatory regimes. Here we've done our own thing. We've got something which is different from all of the rest. Now I'd just like to say another word of thanks there, because as a lawyer, that means that we lawyers are going to have to figure out what it means, rather than take the UK or the Australian regulatory system and just apply it. We've gone to do something different. So another word of thanks there from those of us that operate in the law. There are aspects of this legislation that I don't understand, and it will take the court to resolve. But the thrust of it is clear. It's there to protect payments down the construction chain. It's now law. It's in a curious position. We have the law, that is the Construction Contracts Act, but that law has not yet been implemented. So although it exists, it's not in effect. And before it can come into effect, there are a number of things that have to happen. There are protocols that need to be put in place, particularly for how the adjudication provisions are to work. There's an adjudication panel to be put in place, so we have to understand where the adjudicators will come from that will make the dispute resolution process work. And then the Minister has to sign an enabling order. And many people ask us to predict when that will be. I've given up on that. It certainly isn't going to be between now and Easter. Hopefully it will be between this Easter and the following. But I would like to think it will certainly be before the next general election. So, what does this piece of law consist of? It's not a difficult piece of law. It's relatively accessible. It's easy to read. You can go onto their Optus website, you can download it, and you can read it. And actually, for those of you that will come to use it as engineers or as quantity surveyors or as project managers, it's pretty accessible. It's pretty clear what it is you're supposed to do. It's written in relatively plain English. It doesn't take a deep understanding of legal principles to see what it's supposed to do. The murkier edges are where, as a lawyer, we test the edges of that. And if you're skirting at the edge of adjudication or the payment processes, then exactly where those edges are is difficult to define. It's separated into 5 parts. Sections 1 and 2 tell us what the Act applies to. Sections 3, 4 and 5 deal with payment and how payment will operate. And then the adjudication provisions are in sections 6, 7, 8 and 9. And then the enabling commencement provisions in sections 10 through to sections 12. And then finally, there's a schedule which sets out certain rules if you don't manage to have those rules in your contract. So a relatively straightforward piece of legislation. 1 and 2 to tell us what it's about, what the payment regime is, what the adjudication process is, when it's going to be enabled, and then finally a schedule. It'll apply to everything. Anyone who is involved in the construction industry, this will touch. It is a wider piece of law than that in the UK. It even includes artists doing things on construction sites. So if you're involved in construction, either as a consultant or as a subcontractor or a subcontractor, it will catch you. The only significant exclusion is supply. If you supply only to the construction industry, then you're not caught by the Act and its protection. So the supply side of the industry was excluded, presumably because they just don't deliver if they don't get paid. I don't know, perhaps they've got other remedies. So that's the only significant exclusion. Everything else is likely to be caught. If you're involved in construction into the consumer end of the industry, then you're also likely to be outside the remit of the Act, because the Act does not apply to dwellings less than 200 meters square, or to contract values less than €10,000. So very small contracts or residential occupiers in small dwellings are not included within the ambit of the Act. Now, it's less clear where that will be than in relation to the overall industry, and one of the areas that's highly likely to be the subject of considerable litigation is just exactly, particularly the €10,000 ceiling, how that will operate. Doesn't apply to employment contracts, doesn't apply to PPP schemes, so big financial schemes, rental schemes, that kind of thing, it doesn't apply to either. But that's I think most of us wouldn't regard those as construction contracts. Everything else is caught. Subcontractors, consultants, QSs, architects, all caught by the Act. Okay, the payment regime set out in Section 3 and Section 4 particularly is a new process. It is a new and rigid process, which means a new culture. One of the striking things about the way that the Construction Contract Act unfolded in the UK was how it gradually changed the UK culture, not beyond what we would recognise here, but certainly into something that is much, much more clear-cut, where big abuses are much less frequent. The blackguardry that goes with a lot of construction contracting, I can't pay you because I haven't been paid, those kind of conversations, illegal in the UK since 1997, but a while for that culture to completely transform the industry. And now it has. Now it would be very, very unusual, even at the murkier ends of the construction industry, to see those payment abuses that were endemic 15 or 20 years ago. So we can expect a similar culture change. No pay when paid, and a structured system, a statutorily obliged structured system for payments. Many main contractors, I am sure, will have to explore the edges of that to protect their own positions. And many clients will be forcing main contractors to the edges of the comfort zone that this statutory structure will impose on them. And that's another area of uncertainty. Okay, I'm going to cover the timescales for this new payment mechanism that are set out in the schedule. But all of it revolves around what the Act describes as a payment claim notice. So payment claim notice, PCN, or whatever it comes to be called, is going to be the conversation. What is a payment claim notice? What was in it? How much you're due to be paid on foot of it? And I think we'll gradually see a reduction in language which talks about certificates or certification, applications for payment, invoicing, that kind of conversation to be replaced with this statutory concept of a payment claim notice. And the law sets out what needs to be in that payment claim, which is pretty straightforward, what work it is that the payment claim refers to, how it's been calculated, must be in the payment claim notice. And it gives then the payer the opportunity to respond. So responses to payment claim notice is the new language. There's also not just a right to respond, but also a right to suspend work for non-payment. And one of the things that is a potentially potent game changer for contractors and subcontractors is this statutory right to suspend work without having their contracts terminated or running the risk of having their contracts terminated whenever they're not paid. And so it gives contractors and subcontractors, the payee end of the industry, a much, much more powerful tool to actually be taken seriously. Hang on, not that. Right, so the payment mechanism is made live by the schedule to the Act. Quite straightforward, simple to read, if not necessarily simple to understand schedule for how payments will work. For main contractors, if the payment process in your main contract doesn't exist or doesn't comply with the Act in another way, then you revert to the schedule. For subcontractors, you get the schedule unless the subcontract is more beneficial to you. And I know that both John and Paul alluded to difficulties that main contractors may have with that issue, but there it is. So subcontracting will be at least as good as the payment in the payment process in the schedule to the Construction Act, or better. It turns on a 30-day period, so it's not monthly and it's not 4 weekly, it's 30 days. It talks about final dates for payment in 30 days from the payment claim notice, and it talks about a payment date being 14 days from the payment claim notice, so you get like a long stop. It talks about how the valuation of the payments work, and the description of that's a little bit odd. Those of you that have perhaps looked at the Act already, one of the things that is curious is the way that the schedule describes the valuation and total amounts to be paid, and puts a ceiling on them at the contract value. And exactly what that means is not clear from a legal point of view. But what is clear is that it's short timescales, 30-day timescales to turn payments around. The way that the process is set up comes in 2 types. For contracts which are greater than 45 days, then you get this setup. From you start on site to the first payment is 30 days. That's the date of that's the payment claim date. And from that, within 5 days of that date, the supply side issues the payment claim notice, the PCN. Within 21 days of the payment claim date, the payer can issue their response to say that that's the sum, the PCN is what they're going to pay, or if they're not, what the sum is going to be. And then 30 days from the payment claim date, the payment is made, or the contractor has a right to suspend. So very short timescales. And then on that 60th day, then the payment cycle starts again. So 30-day periods up to the date of payment. The other option in the schedule is for short contracts, for contracts which are estimated to be less than 45 days. And that is a curious problem in that it pushes the payments right out. So from the commencement date, you've got 45 days to complete the works, then 14 days to issue the payment claim date. 14 days to the payment claim date, then a payment claim notice 5 days after that. Again, 21 days from the payment claim date to issue the response, and then 30 days beyond that until the payment's made, which actually makes the payment date 89 days after you start on site for contracts which are expected to be less than 45 days. Slightly curious that it's a faster payment process for longer contracts, but there you go. So that's how the schedule operates. All of it is underpinned by rapid dispute resolution. What the adjudication provisions are there to do is to try and deliver rapid decisions where disputes arise. The vast majority of the problems that I see about payment are not actually about the payment of an agreed sum that is due or a properly determined sum that is due. They're problems about bogus or apparently bogus disputes in relation to a payment. One of the ways in which unscrupulous payers prevent money being passed down the supply chain is to claim that there is a dispute. The goods that you brought to me were defective. The work that you didn't comply with the contract. I'm allowed to withhold money from you because you didn't finish on time. You're not entitled to additional money because the direction that I gave you was not a change order. It wasn't a compensation event. And large sums of money turn on that. And if those issues cannot be resolved quickly, then the entire act is toothless, because it is so easy to make sure that payment doesn't flow down the supply chain. And the remedy for that is adjudication. So adjudication is designed to be a rapid dispute resolution process that encourages cash flow. It's defined in Section 6. What adjudication in this jurisdiction is defined in Section 6 of the Construction Contracts Act. It's a temporarily binding process. Some of you will have heard of the conciliation process, which is a way of resolving disputes, but is not binding unless both parties agree, whereas adjudication is. So it's enforceable, even though it can always be appealed. It's a process that will get to a resolution in 28 days, with a way to extend it if people agree, but still basically 28 days, which is extraordinarily fast whenever you compare it to the processes we have at the moment. It turns on the notification of adjudication to the appropriate appointing body, the panel, which is yet to be established. The dispute is then referred to an adjudicator, and a response is to be provided by the other side, and then the adjudicator gets on and makes his decision in an eye-wateringly short space of time, with very little proper investigation in the way that we would understand it, certainly from an arbitration point of view. And then underpinned with a right to suspend work for failure to comply. So where a payee doesn't get the money that the adjudicator decides, then he has a right to suspend work. Some of the funnies about the adjudication process that we have here that contrast it with what adjudication is north of the border or across the water. First of all, it relates to what's described as a payment dispute, and it is not entirely clear what the difference is between any dispute and a payment dispute, because ultimately everything turns on payment. Everything is related to payment in some way. The appointing of adjudicators and how the powers of adjudicators are limited is something that is unclear. It is absolutely clear that we have not adopted the British system. It's going to be different from what happens across the water in Northern Ireland, but what's replacing it is not clear. And finally, there's an issue about how much adjudication will cost, how much the process will cost. It'll certainly cost something in terms of payment of the adjudicator. Again, the British example would tend to suggest that most things are going to cost between 3,000 and 5,000 euros to resolve. So you're not talking about resolving minor disputes unless you're very clear you're going to win. So that tends to be one of the things that concerns us. The sequence is very straightforward. So you prepare before the adjudication, and I have to make it absolutely clear that the Construction Act is not going to sort out people that can't put their contracts in order. If your agreement is a shambles and nobody really knows who's supposed to get paid for what, well then it's going to be expensive to untangle that. Notice the appointment, the referral of the dispute, how that's replied to, are all things that for those of you that are looking to a long career in the construction industry, you'll want to become familiar with. There's no need for a lawyer to be involved in referring something to adjudication, and certainly in the UK, still many adjudications aren't touched by people like myself. So something that is open to normal construction professionals to operate is what we would expect from the adjudication process. It then gets concluded, often without a hearing, often without a day in court in front of the adjudicator, but on documents only. And then the adjudicator issues a decision, which if he's done his job competently, will be binding. Some differences: it's not negotiation, it's not mediation because it's not consensual, it's not conciliation, although it's more like conciliation in that the conciliators tend to express their views more. And it's not quite arbitration in that it's not finally binding, so it shouldn't be anything like as expensive. It's a rapid, relatively informal dispute resolution process that decides whether the baby's going to be cut in half or not, to echo King Solomon's approach to justice. And many see it in that way. Couple of points just about adapting for change, just to conclude with. what's going to change? Well, I don't know what's going to change. Certainly, the implication is that the culture is going to change, that the formalities associated with the construction industry are going to change. That would be part of the UK experience. There's certainly going to be pressures on main contractors because the balance of the Act, favours the payee, whether he's a main contractor or subcontractor. But as between a main contractor and a subcontractor, there are challenges for main contractors to make sure that they get their subcontracts in order and make sure they have that side of their business properly organised, perhaps in a way that they haven't been used to seeing. There are these new bits of new terminology, payment claim provisions are talking about payment claim notices and payment claim dates and how that operates. And that, if it's going to be operated at all, will be about a stricter approach than we've seen so far. From a payee point of view, from a contractor point of view, you can continue to do what you want to do until you fall out, and then you can revert to the statutory system. And that means that from an employer point of view, you've got to start from the beginning to make sure that your contractual process complies with this, and the way that you follow it complies with it, if you're not going to end up being ambushed by it. And that will be a culture change. And then the last one there, how likely are you to come across adjudication? I don't know. Initially in the UK, there were upwards of 20,000 adjudications a year. That has dramatically calmed down to something of the order of 1,200 adjudications a year. And if you compare the size of the construction industries across the whole of the UK and here, that probably means something under 100 adjudications in Ireland. And that would reflect the Scottish experience. In Scotland, there's typically less than 100 adjudications a year that are appointed through appointing bodies where we can record this. And indeed in Northern Ireland, where there would be a smaller construction economy than here, where the number of adjudications is counted more in tens than hundreds. But yes, if you've come across conciliation, you will certainly come across adjudication. And for those of you that look to a long career in construction in Ireland, you will at some stage come across the adjudication process. Fine. There you are. I think there's questions now, Martin. Is that Thank you.